Hi, hello. I am Robert Temmink. I'm one of the barristers at Quadrant Chambers, and this QBiT talk is about how to obtain a committal order. So, what is an order for committal and how do you get one? Order for committal is defined in CPR 81.2, and it means the imposition of a sentence of imprisonment, whether immediate or suspended, for contempt of court. So, how do you obtain a committal order? It's easy. Have someone found guilty of contempt of court. Bit of history. The substantive law on the history of contempt of court was a nightmare. They were a load of ancient common law powers and modern statutory innovations filled with potential traps for the unwary. There were awkward distinctions between civil contempt and criminal contempt, contempt in the face of the court, contempts punishable by superior courts of record but not inferior courts. It was, or could be, overwhelming. So let's narrow it down. We've only got 10 minutes. Contempt that arises in civil and commercial litigation in the High Court in existing proceedings. That's what I'm going to talk about. Give you two examples. Deliberate breach of a freezing order or a search order that contains a penal notice, or a witness who's lying or has tampered with evidence in the course of a trial. And I'm going to suggest that the process for those sorts of problems is relatively straightforward. But sending someone to jail is serious. So 3 points. First of all, you have to remember that in all contempt applications, it's the criminal standard of proof, i.e. beyond reasonable doubt, or so that a court's sure that a contempt's been committed. Secondly, you're in a quasi-prosecutorial capacity and you're acting in the public interest. The application has to be pursued and presented dispassionately and fairly. If your motive is revenge or animosity, it can be struck out as an abusive process. There's authority for that, Navigator Equities and Deripaska. Courts guard the procedural fairness of contempt applications, and there's a lot of judicial anxiety about compliance with Article 6 of the European Convention on Human Rights and the defendant's right to a fair trial. The procedure has to be right. So, Part 81, this is going to be your friend. Revised in October 2020, now only 10 basic rules and no practice directions. The terminology's changed a bit, so while the ultimate goal is an order for committal, the application for committal is not called a committal application, but rather a contempt application. Small point, but you may as well know the lingo. The respondent to an application is a defendant, even if they're the claimant in the underlying proceedings, and the person who brings the application is always called the claimant. So how do you bring an application? The method depends on the nature of the contempt. And in our narrowed focus, contempt in existing proceedings in the High Court, it's an application under Part 23. It's heard by a High Court judge in the relevant division, and that's set out in Part 81.3. Here's your next friend in this process. It's Form N600, and it's the form that has been produced in Part 81 for these Part 23 committal applications. As we'll see, the N600 does a lot of the hard work in ensuring that the proceedings are brought with fair notice and protecting the defendant's Article 6 rights. You need permission to bring an application in some circumstances. An allegation of knowingly making a false statement in any affidavit, affirmation or other document verified by a statement of truth or in a disclosure statement requires permission. But a contempt application arising from lying in the witness box does not by itself require permission. However, it's extremely common that a lie in the witness box, which doesn't require permission, will be a repeat of a lie contained in a witness statement, which does. And the best practice is this: seek permission, because the court looks down on any attempt to circumvent the need for permission by careful framing. You don't need permission, however, for an application for contempt for breaching a court order which contains a penal notice. Where you need permission, the N600 sets it out. It's printed on the form itself, and the test is this: is it in the public interest for the contempt application to proceed? And that's judged by reference to the seriousness of the contempt and the strength of the merits. And on that, you need at least a strong prima facie case of contempt. The authority for that proposition is Ocado and McKeeve in 2021. So what are the requirements for an application for contempt? In general, every contempt application has to be supported by written evidence given by affidavit or affirmation. And the affidavit gives details and particulars of the contempt and exhibits documents in support. It's usually from a solicitor, but a witness can also give the affidavit. What do you have to put in an application? There are 19 things. I told you this was simple. The list includes the obvious, a statement of the nature of the contempt, the date and terms of any order that's been breached, confirmation that any such order was served. And it also includes information on the defendant's rights. It's designed to ensure that Part 81 is compliant with Article 6 of the ECHR. For instance, it tells a defendant that they have a right to be legally represented, that they have a right to legal aid or may have a right to legal aid, and that there's a reasonable amount of time to be given to them to prepare for a hearing. It also says they may choose to apologise to the court for their contempt and that may reduce any punishment. Most of that's pre-printed on the form, so you don't need to worry about it. The focus when you're making an application is primarily on giving proper and detailed particulars of the contempt on the particular facts that you're arguing about. Not only are clear particulars fair to the defendant, but good and simple drafting helps to avoid costs and delays to the claimant as well. And the court will adjourn an application if the defendant doesn't understand the nature of the allegations against them precisely. So, be clear, be concise, be fair. You're a quasi-prosecutor. You also have to serve your application, and in most cases, personal service is required. There are some exceptions. For instance, if the contempt is committed in existing proceedings and the defendant's got legal representation, then you can serve those legal representatives. They can object to that service, but fundamentally that's one route. You can also apply under Part 6 to dispense with service or to modify it, but those applications are rarely granted. There's then a smorgasbord of further provisions. 81.6 confirms that the court can initiate contempt proceedings of its own motion, but can require the other parties to cooperate and assist. 81.7 confirms the court will set directions for the hearing, and the shape of the contempt hearing will really depend significantly upon the nature of the contempt. The court can compel a witness to attend by bench warrant, but a witness cannot be compelled to give evidence. Hearings, they're always in public, unless the court orders otherwise, and the Press Association can make submissions before any order is made for a private hearing. Advocates are always robed, all judgments must be made public. Then we get to the juicy bit, punishments. What can you get at the end of a contempt application? The court can make 3 orders, principally committal to prison, a fine, confiscation of assets. Then finally, in Rule 81.10, that explains that a defendant can apply for a committal order to be discharged by way of an application under Part 23. And that is how to obtain a committal order in 10 minutes.